Good morning to you all and to our esteemed panel members as well as all of our partners. My name is Khuraisha Patel and I am part of the secretariat of the organizing committee, Open Secrets, and we would like to extend a very warm welcome to all of you to the first People's Tribunal on Economic Crime, scheduled to run here at Conhill from the 3rd of February to the 7th of February. Open Secrets, in conjunction with the rest of the organizing committee, who are the Right to Know campaign, the Foundation for Human Rights, PARI, the Public Affairs Research Institute, Corruption Watch, as well as CALS, the Center for Applied Legal Studies, welcomes you. And of course, we would like to extend a warm thank you to our organizing committee for all their help in realizing this tribunal. In addition, I'd like to extend a very big thank you to our funders, and these are the Claude Leon Foundation, Open Society Foundation of South Africa, the Heinrich Boll Foundation, as well as OSF Human Rights Initiative. I would also like to introduce our esteemed panel members, and I'll start with my immediate left, Dr. Navi Pillay. Dr. Navi Pillay, some of you may be familiar, is our former United Nations High Commissioner for Human Rights, as well as a former judge of the High Court of South Africa. Dr. Navi Pillay has also served on the International Criminal Tribunal for Rwanda, as well as the International Criminal Court. Next to Dr. Pillay, we have Ms. Mandisa Dianti, Deputy Secretary General of the Cape Town-based Social Justice Coalition and a renowned community rights advocate. Former Justice Zak Yacoub, Justice of the Constitutional Court, here in a very different capacity for us today. He has also served on the International People's Tribunal on the 1965 Crimes Against Humanity in Indonesia. Very brief introduction, but there's much more to say, of course. Beside Mr. Yacoub, we have Ms. Alison Gibson, former Attorney General of the Bahamas, community rights advocate, and former Minister of Financial Services and Investments. And finally, Mr. Dinga Sikwebu, leading labor rights activist and co-director of the Chishimani Center for Activist Education. I would just like to hand over to the judges for some preliminary points that they would like to raise before the official start of the proceedings, when our civil society organizations will be making their presentations, and I will introduce them accordingly. Apologies again for the delay, and thank you for your patience while we set up and got this going. So I'd like to just hand over to our esteemed panel members for any preliminary points and statements that they wish to make.
Thank you very much. I would like to start by reading an opening statement on behalf of all of us, so that we know exactly what we are about. This is a people's tribunal aimed at finding the facts concerning allegations of very serious economic crimes. One, having been committed during the apartheid era, that largely violated United Nations arms embargo and the mechanisms allegedly employed to achieve that violation. Two, economic crimes that have been involved in the facilitation of the 1999 arms deal. And three, allegations that public enterprises have been captured for the benefit of private entities rather than the public. This is not a court of law, and we are not here as judges. This is a tribunal which has no legal standing or authority. It is hoped that by the time the work of the tribunal is completed, it will be possible to demonstrate a degree of moral authority on behalf of the people of this country. We will listen and consider all of the evidence without fear, favor, or prejudice, and find the facts as we see them. We hope that in the process of finding the facts, this tribunal will, at the very least, discover the truth. This is because the people are entitled to know what the truth is. We have chosen to commit to the task of adjudication of this case because we think it is vital for the future of our society to find out what the facts really are regarding these allegations. Excuse me, got the wrong one. We would not have agreed to be part of this tribunal if we had believed that there is no substance in these allegations. We think, though, that it is important to put this issue to rest. We hope that at the end of the process, we will be able to make recommendations that will ultimately result in better accounting for economic crime in the way in which it will take our society forward in the interests of the people of this country. That is the end of the opening statement, and it may be that before we have a preliminary issue to raise, and before we raise it, it might be a good idea for those appearing as evidence leaders to identify themselves so that we know who we are talking to.
Good morning, members. My name is Nyoko Muvangwa, and I'm a member of the Johannesburg Bar. I appear as an evidence leader with two other colleagues, also members of the Johannesburg Bar. One is Francis Hobden, and the other is Mkululi Stubbs. I believe that they are on their way still.
Okay. So we had given notice to the organizers yesterday that, and I hope that the organizers communicated it to you, that the first issue we were going to raise is the issue of notice. We have been asked as a panel to make recommendations, to make findings of fact and to make recommendations, and the findings of fact could well be against one entity or another. If we find that Denel, for example, did some terrible things, then Denel has to know that that finding is about to be made. If we find that the members of the South African government did some terrible thing, they need to know beforehand there's the possibility of these findings being made so that if they wish to respond to them, they could do so. We are worried about this, and therefore we thought that we should start these proceedings by hearing full argument on the issue of notice. If you haven't received notice of this, then, and if you want 5 or 10 minutes to work out what your approach is going to be, we will give it to you. But if you are ready to argue the issue of notice, we'd be very happy to hear you. Our concern really is that we should hear from both sides, and the other side should be given a fair and reasonable opportunity to comment before we go forward. That is our difficulty, and we would like colleagues who appear before us to help us decide this question and help us see a way forward. So can I hand over, do any of my colleagues have anything more to say on this issue? Okay, over to you.
Thanks, Member Yakub. If I may, I would like 5 or so minutes to consider an answer that I would give, but I must say at the outset that the issue of notice is an integral part of our legal system because it gives rise to a right of reply. However, I would like to provide a more considered answer in 5 or 10 minutes, if I may.
Right. Will you let us know? Don't feel under pressure. Just let us know when you are ready. So we will suspend our work for 5 minutes. Thank you very much.
I'll oblige.
Or as soon as we are told. Therefore, we should proceed with the evidence that there is, on the basis that they will deliver argument to us on the notice issue at 1:45 today after lunch. And I want to say that if they're not ready by 1:45, they must tell us, and then we'll continue with the evidence. But the latest we will hear argument on the issue of notice is tomorrow morning. We can't carry on for too long without the notice issue. So can we please proceed with the evidence?
We are indebted to the panel.